This is in the interest of Tremaya Campbell Johnson. We are here today for a special hearing. The case is on appeal, and the Court of Appeals has abated the appellate proceeding and asked me to hold this hearing regarding, I guess, Ms. Campbell's request to act pro se in the appeal. Ms. Bethany Stevens was appointed as her appellate attorney. Ms. Stevens, just so that we've got all this on the record, what is the status of what you've done so far in the appeal?
I was just adding it up. I've done about 25 hours worth of work already on it. I've reviewed the entire 489 pages of trial transcript, 212 pages of the clerk's record. I've already done my legal research on the issues. I was just about to start the brief when, after multiple requests for me to withdraw, I filed the motion that I filed. And now we're having this hearing. So I've stopped at this point.
Okay. And they've abated. So, all right. So also, let me just, for the record, present today, Ms. Powell, Melinda Powell is present for the Department of Family Protective Services. Stacy Zavala is present on behalf of the child, Tremaya Campbell. And then we've got Jennifer Campos and Ms. Har from the department in St. Francis present with us. Okay, so no brief has been filed.
Not yet, Your Honor. I was starting to draft when they abated.
All right. Okay.
But Your Honor, just for clarity, I'm not sure if you saw it on the back of the motion that I filed with the appellate court. The client had filed a 34-page pro se motion to remand to the trial court for conflicts of interest. It's not in proper form or anything like that. So with an attorney of record, they didn't act on it. I had told my client that if there hadn't been an attorney on record, they would have just dismissed summarily because that wasn't in proper form and didn't follow the appellate rules of procedure.
All right. And that sort of leads us kind of into the general area that we need to cover today. So Ms. Campbell, I'm going to ask you some questions, but I'm going to put you under oath before I do that.
Yes, ma'am.
I don't have video, but will you raise your right hand for me?
Yes, ma'am.
All right. Do you solemnly swear that each of the answers you give today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. First of all, Ms. Campbell, let me ask you, do you know why we're here today?
Yes, ma'am.
Okay. Can you tell me why you think we're having this hearing? What do you think this is all about?
To see if you, I don't know. I don't know really. I'm not sure.
Well, okay. So let's try to narrow it down. You filed something with the Court of Appeals, which I think has been rejected, but what you filed, was it your intent to tell them that you want to represent yourself in this appeal?
Yes.
Okay, and can you tell me why you want to do that?
I just feel more comfortable, yes.
Do you have any, I mean, we've been through this, in the underlying trial, on a number of occasions, you indicated you wanted to be, you wanted to represent yourself and be pro se, but when it got down to the trial, then you finally told me, no, you wanted to keep your lawyer. You recall all that?
Yes, I do.
Okay, so at that time, I asked you a lot of questions about, the danger of representing yourself in a case when you have no legal training. Do you remember me talking to you about the fact that you'd be held to the same standards as the other lawyers in the case?
Yes.
So that would hold true now as well. And the rules of appellate procedure are in some respects maybe even more complicated than the rules that just apply to your case at the trial level. So, you know, not only would you be tasked with understanding the record of the trial that we had, but then you're, in addition to that, you'd be tasked with understanding the rules of properly perfecting and getting your appeal before the Court of Appeals. It's a whole different set of rules, but you would have to have a working knowledge of both of those things to even know how to proceed. And correct me if I'm wrong, I don't recall that you've ever had any legal training. Is that correct?
Correct.
You've never been to law school.
No.
You're not a paralegal.
No.
All right. So if you can explain to me why you think you would want to do this on your own as opposed to having a professional attorney handle this for you.
Because I just feel, I don't know. I don't know.
Well, that kind of doesn't, is it going to help the Court of Appeals? I mean, that's kind of not a good enough answer for them. So let's back up for a minute and let's cover a couple of things that I think we could all maybe agree on, or you can certainly answer the questions. So the first question is, do you still want to pursue your appellate rights? Do you want to appeal the decision that the jury rendered in your trial?
Yes.
All right. Has your financial situation changed at all or substantially changed since the time of our trial?
My financial situation.
In other words, you qualified for a court-appointed lawyer during the underlying case. Have you
Yes.
gotten a new job? Have you won a lottery? I mean, have you come into an
No.
inheritance or something that would have changed your financial situation?
No, ma'am.
Okay. Are you working right now?
Yes, ma'am.
And where are you working?
I'm the same place I've been working for 6 years at Waffle House.
Okay. Have you had any promotion or change in income?
No, ma'am.
All right. How much do you make per hour?
Just depends on my tips. But I make $3.50 an hour.
Okay. And on a weekly basis, about, I mean, and I know it varies week to week, but on average, how much money do you make in tips?
Bring home about like 300 a week.
Plus your $3.50 an hour?
Yes, ma'am.
And
Oh,
how
that's
many?
included.
Oh, that's included?
Yes.
How many hours a week are you working?
30.
Okay. All right. And so you haven't come into any other money or anything like that that would have changed anything else about your financial situation?
No, ma'am.
Okay, Ms. Campbell, has your marital status changed?
No.
Okay. Are you still living in the same place, or has anything changed about what your monthly expenses are?
No, I'm still living in the same place.
Same place? Has your rent changed at all?
No, ma'am.
Do you have pretty much the same expenses now that you had back when we went to trial in your case?
Yes.
Okay. At the end of the week, when you've paid your bills, do you have much money left over?
No.
Okay. All right, so the first prong that they've asked me to determine is whether you wanted to prosecute the appeal. You've told me you do. The second prong is whether you remain indigent. And based on what we've talked about, I'm going to find that you are still indigent and you still do qualify for court-appointed counsel for your appeal. Now, let's come back to the real tough issue, and that's whether or not you want to do this by yourself, and if you really understand what you would be doing if you made that decision. So, again, I'm going to ask you, why is it that you think you would be more competent or better to pursue your appeal than Ms. Stevens? Or any other attorney for that matter?
Because like I've had 3 attorneys. No one's like the attorneys I've had so far, that which was court appointed, have not even worked with me. Like no one's gonna fight harder for my daughter than I am.
Okay, but you understand that it's this is not just all about fighting for your daughter. There are rules and procedures and certain ways that a brief has to be submitted in a certain form, and it has to have supporting case law and authority. And you will be held to the same standard as what Ms. Stevens has already done for you and is prepared to do for you. Do you understand that?
Yes.
Do you know how to write a legal brief to an appellate court?
No.
Do you have the assistance of somebody that has that knowledge?
Yes.
And who is that?
It's a friend of mine. She works for a law firm.
Well, is she willing to go on as your attorney of record?
I'm not sure. I haven't asked her.
Because that's a little tricky. As far as her trying to assist you sort of behind the scenes, so to speak.
Mhm. Yes, ma'am.
I mean, are you looking to her to actually prepare the written documents that are going to be filed and to do the research and all of that? Is that your plan?
I guess yes.
Has she agreed to do that?
Well, I mean, she hasn't disagreed. She's been helping me so far.
Did she help you with this document that you filed with the Court of Appeals recently?
No, actually, my sister did that.
Is your sister an attorney?
No,
Does she have any legal training?
no.
So are you telling me that you really would not be doing this on your own? You would be relying on the assistance of these other people?
I'll rely on whatever assistance I can get. But yes, I'll be doing it on my own.
Do you feel like you understand that if things aren't prepared correctly, filed correctly, presented correctly, that it's unlikely that the Court of Appeals is going to accept those and probably not even look at those.
Yes, ma'am.
And would you agree with me that if they don't look at anything, or can't look at anything because it's not properly presented or filed, that's going to put you at a real disadvantage.
Yes.
Would you agree with that?
Yes.
Then why would you want to put yourself at such a disadvantage?
Not sure. Not sure.
Well, I mean, you're kind of setting yourself up to fail, Miss Campbell, aren't you? I mean, if you don't know how to do it and nobody's going to help you, or, you know, if it's not done correctly, then your appeal is not, you're going to run out of time and it won't proceed. You know, because there's a time element to all of this. Everything
Yeah.
that's done has a time limit and a time guideline on it.
Okay.
And if you persist in representing yourself, you know, they don't have to cut you any breaks or give you any special treatment about these deadlines and how things are filed and presented.
Yes.
And so if the rules aren't followed, then, you know, essentially you may not get your appeal perfected or heard.
Okay.
You understand that?
Yes.
And knowing all of that, are you telling me that I mean, that, are you telling me, first of all, that either you want to represent yourself or are you wanting me to appoint you different counsel?
No, I'd rather represent myself.
In even in light of all the mountains that you have to climb to get this
Yes.
thing done and submitted correctly.
Yes.
Ms. Campbell, do you understand that an appeal is not a do-over of the trial? I think a lot of people don't understand that. So let's talk about that. Do you understand that it's not like you just go and have another whole trial?
Yes.
Okay, well, tell me what you think is looked at and what the Court of Appeals does.
I'm not sure actually. I've never had to appeal anything.
Well, if you're not sure at what they look at or what they do, how are you going to write an appeal that spells out what you're wanting?
I have no idea.
Okay, and that's my whole point. It's just like when we got ready for trial, we had a jury sitting there waiting, you know, and you know, I admonished you repeatedly at what a horrible disadvantage you were going to be at without counsel. And I think you wisely made the right decision to allow your attorney to continue to represent you through trial.
And I was still at a disadvantage.
Well, I mean, I would probably disagree with that statement because your attorney is a very experienced attorney. It is widely respected in the legal community in the Panhandle of Texas. So I'm going to just say I would disagree with that statement. You know, I also was very comfortable with the fact that he was representing you, that you did have such capable and competent counsel. The same is true with this appeal. You have capable and competent counsel handling this for you. But I want to make sure you understand it's not like you start all over again and you're going to have all these hearings in front of the Court of Appeals, and that
Right.
you're going to go back in time and they're going to hear this thing all over again. That's not how it works. Do you even know what you're appealing?
Do I know what I'm appealing?
Yeah. Do you know what you
The
are
decision of
appealing?
my rights being terminated.
Okay, well, yeah, I mean, we understand that, but there are specific things you can appeal. Do you even know what you want to appeal? I understand
No.
overall you don't like the fact that the jury terminated your rights, but what is your argument to the Court of Appeals that they should change that? I'm trying to determine what you know or what you don't know about the appeal process.
I don't know too much.
You understand that Ms. Stevens' job is to review, when I say review the record, okay, you remember while you were in the courtroom with us,
Yes.
we had a court reporter,
Yes, ma'am.
and she takes down everything that gets said. You remember us talking about that?
Yes.
Okay. So all of that gets transcribed into this great big document. And all the evidence and, exhibits and all those things get put in, and that becomes part of what we call the record. Ms. Stevens has already thoroughly reviewed that record. In other words, she has read through the entire transcript of the trial. And she's trying to put together your arguments to the Court of Appeal of why they should overturn the jury's decision to terminate your parental rights. Do you understand that?
Yes.
Okay. So she's going through that, pouring through that to see, were there mistakes made? Or was there anything that was contrary to the laws of procedure or evidence or all of those kinds of things? Do you have any knowledge about the Texas Rules of Civil Procedure?
No.
Do you have any knowledge about the Texas Rules of Evidence?
No, ma'am.
Would you know if there had been a mistake made in trial, say about allowing some piece of evidence in that shouldn't have been? Would you even recognize that?
Yes. I believe I would.
And that's, how would you know that if you don't know what the rules are?
I don't know.
I mean, liking something or not liking it, that isn't one of the rules.
Right.
And feeling good about it or feeling bad about it isn't one of the rules.
Right.
So would you, I mean, is it a fair statement that to know whether a rule has been broken, you got to know the rules in the first place?
Right.
And you're telling me you don't know those rules.
No.
Then I'm just going to ask you again, how do you think you're going to be able to do this by yourself?
I'm not sure, but I don't know.
Okay. You repeatedly said to me that you don't know. That's been the answer to a lot of your questions today. I don't know.
I mean, because I've
And-
never had to do this before, but I'm willing to. I'm willing to learn. I'm willing to do it.
Well, you understand that attorneys go to law school for 3 years to learn, and that's just the beginning of knowing what they're doing. You don't have 3
Right.
years to learn to do this, Miss Campbell.
Correct. But I
Once,
have my daughter's life at stake, so I'm pretty sure I'm capable.
well,
Your Honor,
yes.
I believe I could summarize her issues better. I don't feel like she is getting her feelings across. With your permission, I'd be happy to try to summarize it a little bit better so you can address the concerns that she has,
That'd
if
be
you'd like.
fine. That'd be fine. I want a really good, complete record of her
Okay.
thoughts about this.
All right. And so I went through and made a list of our contacts with each other. Nothing in here is privileged. It's all just about wanting this motion to withdraw. And so if you will allow me, I'd like to go through it so that you could better understand her point of view. I was appointed on December 19th, and Vince had already filed the notice of appeal. I had a brief phone call with Ms. Campbell just to explain that an appeal can only go on the record. I've ordered the transcripts, and as soon as I had a brief, I would certainly send it to her, and I'd keep her informed when the state got theirs and all of that. She emailed me during the Christmas break, and I didn't respond until I got back from Christmas. Her email said that she didn't want me to be her attorney because she'd read some bad reviews on Google, and that she'd hate to have to fire me like she's fired all of the others, and instructed me to move to withdraw. I emailed her back on January 5th and explained that she's welcome to hire anyone, but that I'm obtaining the records because that's all we can use on appeal, and I don't feel there's an ethical basis for my withdrawal. On January 29th, she emailed stating that she had never received that email from me on the 5th, and that I had obviously not filed the motion to withdraw that I'd been instructed to do, and that I needed to do that immediately. I wrote back and explained again that she could hire any attorney she wanted, but I had no ethical basis to file a motion for withdrawal. She responded and instructed me to file a motion to remand. I responded that I was just finishing up another appellate brief and would start on hers immediately thereafter. And I told her what I planned to argue. I'd prefer not to put that out there right now, but what I had planned to argue, and how I plan to ask the appellate court to rule. She emailed and argued, just told me to withdraw, and then sent me the file stamp 34-page pro se motion to remand that was not in proper form, and that also contained exhibits that were not appropriate on appeal. On January 30th, she emailed and asked if I'd filed the motion to withdraw yet. I said she'd made it very clear to the court by filing that pro se motion that she didn't want me. On February 2nd, she emailed asking if I'd filed a motion to withdraw and said that she wanted me to do it or she would file a grievance against me. I filed the motion for hearing, which brought us here today, addressing her concerns and stating categorically I have no ethical basis on which to file a motion to withdraw. I emailed her to explain it. I sent it to her and explained that there would probably have to be a court hearing before she could proceed pro se. And I did tell her to stop emailing the same demand for withdrawal over and over because we were beginning to cross into electronic harassment. She responded in all caps and said, "You are fired. Please don't make me grieve you." She emailed again later that day and stated that we are all in cahoots because she didn't want a court-appointed attorney, but Judge Baker constantly forces one on her. She said all 4 court-appointed attorneys have refused to withdraw, but end up withdrawing anyway, and I'd be no different. Then she said a lot of things about Vincent falsifying documents, which were not true. On February 6th, I sent her the mandate, order, and judgment from the appellate court abating the appeal and ordering this hearing. I explained that it was remanded back to you to decide if she can do her own appeal and that this would delay the appeal, and that I didn't know when the hearing would happen, but I would let her know. On the 9th, she asked what would happen if you decided she couldn't do her own appeal. I said I would finish the appeal and get it filed as fast as possible. She stated that at this point she didn't know what to do, and that she did apologize for writing me some bad reviews. And then the very next day, I explained again, answering her question about the hearing, that the appellate court wants a hearing to find out if you're serious about doing an appeal, and that what she had filed was not a proper appellate brief, and that we had to have a hearing done. And then once that was done, if I was still on the case, I would file the appellate brief, and the state would have 30 to 60 days to respond. And then there was a lot of emails from her, again, responding with more lies about Vince, accusing me of being cahoots with all of y'all, accusing me of not caring about her child. She said the appeal needed to be delayed so she could get a decent and honest attorney with a backbone who's not from Amarillo. She said that until that's happened, she will represent herself. She said that I'm obviously friends with Vincent and probably Mr. Trout too, and that I could tell them to F off. 2 hours later, she emailed me again and said that I was appointed because I'm buddy with Vince. And she's informed me already that she is firing me and nobody can make her keep me, and that she's already reached out to the State Commission of Judicial Conduct about Judge Baker's conduct as well, and that she'll stop at nothing to expose all of our crooked butts. Trying to salvage that situation, I explained that Vincent and I are not buddy, but we often see one another in court, and that he's always impressed me. She responded the following day with more lies about Vincent, and saying that she's confused as to how I think I should be allowed to stay on the case. On the 12th, I emailed her the Zoom link for this hearing and told her the hearing would be February 19th at 2:30. She asked if it was with the trial court or appellate court. I said it was trial court as ordered by the appellate court. She asked if I was still the attorney. I said yes. She emailed saying that I could at least inform her what the hearing was about, and that I am not allowed to speak for her, that I'm fired and not to speak for her. I responded and explained the motion all over again and what the appellate court had told you to have the hearing about. At this point, she told me to get you to recuse yourself because we're all dirty. And she was going to get someone named Tommy to help her. The next day on the 13th, she emailed and asked if I'd withdrawn. I didn't respond at that point because it was just really beginning to get too harassing at this point. She then emailed later that day and said that my name wasn't on the docket for this hearing, therefore I would not be representing her today. On the 18th, I emailed her, that was yesterday, just reminding her this hearing was ordered by the appellate court because she wanted to represent herself. And then today she just emailed and said she was in bed with the flu and can she be off camera. I said, I don't think that would be a problem, but that I wasn't the judge. I do have concerns about her competency and the fact that she doesn't understand the system. She doesn't understand that there are rules that govern everything. I doubt she'll be able to understand or follow the rules of appellate procedure. The friend at the law firm, I doubt that's a lawyer. I've done a lot of work on this case, but if the court wants to allow her, grant her her wish and allow her to represent herself, I honestly have no objection. I'm happy to stay on the case. I've already done all the work except just drafting the brief. The only thing I would ask the court is if I'm allowed to stay on and write the brief, just to admonish her about electronic harassment.
All right, Ms. Stevens, thank you. All right, just to be sure, Ms. Powell, anything that you want on the record today?
No, Your Honor, I think it's been covered.
Okay, and Ms. Zavala, anything that you want on the record today?
No, Your Honor.
All right. All right, y'all give me just a minute. I want to check on a couple things. Ms. Campbell, just a few more questions for you. Are you still there?
Yes, ma'am.
All right. Ms. Campbell, when we were in trial, you left before it was over, before the jury came back with a verdict. Why did you do that?
Correct.
Why did you do that?
Because I already knew the outcome. Like, the attorney was not asking anything I needed him to ask. He wouldn't even subpoena like witnesses, like any of that. I already knew what it was going to be. And then I'm sitting up here looking at his notes or whatever. They're all wrong dates. So yeah, I already knew what it was going to be.
I've not heard you tell me any valid, justifiable reason why your attorney, Ms. Stevens, should withdraw from the case. I mean, you haven't given me any good reason. She's been doing the work. You've heard how many hours she's put in on this. She's prepared to submit, write the brief, and she's done the research, done the work. I guess I'm not hearing any reason. I'm not hearing you tell me why she should not proceed in perfecting your appeal. I mean, I've heard accusations, but I haven't heard anything that supports any of those things. And I'm trying to give you your opportunity to tell me. Why should I let her withdraw at this point just because you think we're all in cahoots? I mean, that's what I guess you've sent to her. Your words, not mine. I mean, the county's got to pay her for her time and all her effort. You're indigent, you've qualified for a court-appointed attorney, but I also have some obligation to be reasonable with the county's resources too. And you're asking me either to let you do this on your own, which is sort of like agreeing to let you represent yourself in a death penalty case.
Mm-hmm.
And especially in light of the fact that you've told me essentially you don't know how to handle appeal, you don't know the law, you don't know the rules of procedure or appellate procedure, you've basically told me over and over you don't know how you're going to do it. You don't know. That's what I've heard over and over. I don't know. I don't really know.
I don't, but I'll figure it out. This is my child. Like, I'll figure it out.
But you understand you don't have forever to figure this out.
Right.
And the risk if you don't figure it out or you don't figure it out correctly, the risk there is enormous. You understand you might never get your appeal heard or looked at by the Court of Appeals. I mean, you might never get that shot with them, which they're more than willing to give you. But it's got to be done properly. And if it isn't done properly, they can't entertain it. Just like, there were rules in our trial.
Right.
And there are things that, that I don't allow to come into evidence because they're not proper, So we all have to follow the same rules. And if you don't do this correctly, then you most assuredly will once and forever lose your child.
I've already done that.
It'll be over with forever. And
Isn't it
they're willing
already
to,
over?
Ms. Campbell, I'm willing and they're willing to give you the best shot you've got at them entertaining a different result on appeal. But it's got to be done properly.
Yes, ma'am.
And my fear and my true belief is that you're not going to get this done properly and you're going to lose your one shot at this. And I'm not comfortable with you losing that one shot. You know, I know you don't think much of me, and that doesn't even, you know, matter. But I do care that justice is served. And I do care that you get your shot with the Court of Appeals. And that you have an opportunity to argue that position or positions to them. But I'm not confident that you can do that by yourself. And I'm very uncomfortable with the fact that you're telling me you've got a friend who's a lawyer that's going to help you. You know, we
Well, I
kept
said
hearing
worked for a law firm.
she works for a law firm, so she's not a lawyer.
Right. No, she's not a lawyer.
Okay. Well, that's real problematic too, Ms. Campbell, because that's called practicing law without a license. And she could get in enormous trouble for that.
Yes, ma'am.
So I wouldn't rely very heavily on that because, you know, well, bottom line is she's not a lawyer. So, you know, again, you're trying to rely on someone who doesn't know the rules in the process. You know, Ms. Campbell, there are a lot of lawyers out there, but you know what? They aren't all qualified to write an appeal. Most lawyers never write or file an appeal. Did you know that?
Yes, ma'am.
You did?
No, I didn't know that.
Okay. And you know why that is?
Why?
Because it's a very specialized area of the law. And it's a very tricky one to navigate. And if you don't know how to navigate it, you aren't ever going to get to the big show. You're never going to get it heard. You're never going to get it read. So, you know, the vast majority of attorneys don't ever do one. People that
Yes, ma'am.
specialize in it and learn it are a small percentage of all lawyers. So does that concern you that even most lawyers don't even know how to write an appeal?
Yes, ma'am.
And you're wanting to do it on your own?
Yes.
Little scary, isn't it?
Yes.
In light of everything we've talked about today, would you agree that maybe it's better to let Miss Stevens do her job and finish what she started? You can read it before she files it. You have every right to do that. Because, you know, my guess is that everything that she's going to write, that she's arguing on your behalf. She's arguing why your rights should not be terminated. Do you think that would be the smarter thing to do?
It probably would. But yeah, I mean, it probably would.
All right. Okay, to be clear, I will make the findings that mother does still desire to prosecute her appeal. I will find that the mother, Ms. Campbell, is still indigent and is qualified and entitled to court-appointed attorney for this appeal. I do not find that there is any basis for a substitution of counsel for Mrs. Stevens to withdraw. I've heard nothing that would arise to to making that withdrawal and substitution. Going to allow Ms. Stevens to continue to pursue and perfect the appeal. Ms. Campbell, I'm going to find that you really cannot knowingly or intelligently make the decision to represent yourself on an appeal when you have no idea what you're even getting into. So there's just no way you could make a knowing or an intelligent decision about that when you have no idea what the process is. And you've, in fact, now agreed with me that it probably would be the smarter thing to allow a skilled attorney, appellate attorney, to continue to perfect the appeal. I will issue my findings of fact and conclusions of law as requested by the Court of Appeals. So I'll get that done as quickly as possible. We're all on a short deadline. Ms. Stevens, you may proceed. All right, now Ms. Campbell,
Thank you, Your Honor.
I've had to admonish you before about these emails, you know, and this became a problem with my court coordinator. You know, you can't just start emailing folks running off at the mouth, nothing constructive. You know, Ms. Stevens doesn't need the accusations and criticism and all that. What she needs is your cooperation and your assistance. You know, she needs something productive. So if you've got something productive to let her know or to email her about, that's fine. But, you know, all this other stuff just doesn't do anything other than take time away from what her job is. And her job is to argue on your behalf, not argue with you. You know, let her use her time to do the best job she can on this appeal for you, as opposed to trying to field whether or not you filed a grievance against her or whether or not you're going to file one against me. You know, that's not her problem. She doesn't care if you file a grievance against me or not. That's not her issue. So try to be helpful to her as opposed to just hindering her. Do you understand what I'm saying?
Yes.
Okay. I will leave it at that. I'll get my findings of fact and conclusions of law together, and I wish you the very best of luck, Ms. Stevens. Thank you.
Thank
And
you, Your Honor.
I'll get all that filed so we can get back on track.
Thank you, Your Honor.
Okay. Thank y'all. In the interest of Tanya, is it Frere? I hope I'm saying that right. We are here today set for our adversary hearing. We are conducting this through Zoom. We are live streaming. And Ms. Taylor is making our record. All right, Ms. Powell is present on behalf of the Department of Family and Protective Services. Lorraine Lucero is present with her client, Michaela Martinez-Diaz. Mr. Morales is present with his client, Nicholas Ferrer. Ms. Zavala is present along with her client, Tanya Ferrer. And Ms. Zavala, since the child is present with us, do you feel the need of going off YouTube? My understanding is we have an agreement to announce.
You know, I always like to protect her privacy if at all possible. If it's just going to be a short announcement, I think it would be fine. But if we go into any detail, I would request that we go off of YouTube.
Okay. Let's just make, if we just are announcing, I think we'll be okay. Okay, then Ms. Powell, as your understanding, we do have an agreement?
Yes, Your Honor. The agreement is that the department will be named the temporary managing conservator of the child. There will be no findings against the father, Nicholas Fryer. Rather, there is a necessity to rebuild the parent-child relationship between the father and the child at this time before considering placement. There will be visitation set up between the child and each parent. Additionally, the child will remain in her current placement. However, there is an aunt in town that they will begin looking at for placement if the aunt is appropriate.
Right, and this, my understanding, is an Aunt Sandra, and I don't have her last name, but we're talking about one and the same person, I think.
And I can, in St. Francis or department, are either of you familiar with this Aunt Sandra?
Yes, I am.
Do you have a last name?
Diaz, I believe.
And do you need an order for expedited home study, or has that already been ordered?
I would need that, please.
Judge, I also
Um,
asked, I'm sorry, I was just gonna ask if Mr. Perales can emphasize to my client that when Ms. Powell says no findings, she's meaning no findings of abuse or neglect.
That's correct. Sorry, Jerry.
No worries. Thank you. I just want him to be clear.
Back to Sandra. I do know that Tanya doesn't want to be involved. Sandra doesn't.
So she has declined a home study?
I believe so.
Okay.
Patricia had reached out to me and said that she doesn't want to be involved. Patricia is a sister that lives in Washington.
Have you had any contact with Ms. Diaz?
I have not.
Do you know how to contact her?
I can get her number from Michaela.
I would appreciate if you just verify with her.
Yes, ma'am. I will.
Okay. Well, the good news is at least Tanya is placed here already. Do you see any barriers to continuing her current placement?
No, I don't.
Okay. So Tanya, we'll try to check with your aunt and make sure about what she wants or doesn't want, okay? All right. Ms. Powell, are we gonna well, let me ask this. I think, is this a modification? Do we have prior court orders?
There is we received a copy of some prior orders that what we received did not have any custody or possession. However, it did reference some other attachments. Kilm has reached out. I know the department had reached out to them to try to obtain those other attachments. Kilm has also reached out to try to obtain the other attachments. And so this may, depending on what those attachments say, this may end up being a modification with prior orders out of Washington state. Which means we'll have to, at that point in time, well, nobody's left in Washington. Dad's in Georgia and mom is and child are here. So we don't have the problem with UCCJEA in that regards, but we may need to reach out and have them transfer the cake or, allow permission for the case to be here, but we are working on obtaining those. And once we get everything with all attorneys' permission, I can forward to the court and to each attorney.
All right, thank you. At this time, then, we're not ordering any kind of child support for either parent. Is that correct?
That's correct, Judge.
Or medical support?
That's correct, Judge.
Okay, Ms. Lucero, does this sound like what your client has agreed to?
Yes, Your Honor.
All right, and Mr. Morales?
Yes, Your Honor.
Okay. Ms. Zavala, in any recommendation today?
Yes, Your Honor, I do believe that this is in her best interest. As to Aunt, it sounds like there's been some communication back and forth with the sisters in Washington, and it may be that Aunt was aware that originally Tanya had wanted to go and live with sisters in Washington. It may be that her position about being placement might change if she's got the details about how that works. And if it would help, I wouldn't mind having a discussion with her if somebody could provide me her contact info. But I do recommend that Tanya stay in her current placement until we can explore those family options. And I do believe all of that is in her best interest.
Okay, and the child has requested contact with her adult siblings in Washington. Does anybody have any reason or any knowledge that that would be inappropriate for her to have telephone contact with them?
No, Your Honor.
Okay,
I haven't been provided any information. I'm sure if there was somebody from the department would have let us know.
And I have no further information about that.
okay. Well, I don't have a problem with them, starting to have phone contact, and that could, and that can even be video contact. And so that's all fine. Okay, Mr. Perales, if you would just ask if either parent has any questions.
Pues,
Well,
yo en lo que cabe, no sé por qué no me la quieran dar.
I don't know why they don't want to give her back to me. And I would like to see if she can come back with me to where I'm at.
Is that the dad talking?
That is correct.
Okay, I'll do my best to answer that. Mr. Frere, it's just been a substantial amount of time, I think, since Tanya has had, in-person contact with you, and maybe not a lot of other contact. I'm not criticizing anybody or saying it's anybody's fault. It's just the fact of the matter is she's just uncomfortable with that idea at this point. And I think it would be good for us to start by you all having some visits and contact, and we'll just see where that goes. But this situation is very disruptive to a child. And, my goal is to try to make this as easy for her as it can be, and with as little change in her life as that has to be. So we've got her in a really good placement here in Amarillo right now, where, this is home, this is what's familiar. and I want to just keep that until you and she develop a little better relationship. The other thing is that Tanya is old enough that she's got a voice in this and what happens. And so as we move through the case, you know, I may be periodically talking with her about what her wishes are. What she wants today may not be what she wants 2 months from now. So I'm always interested in what she has to tell me.
Okay. That's fine.
All right, sir, I appreciate your being supportive of her and of her current wishes. I think that's very important to her. All right, then. I will find that the evidence is sufficient to name the Department of Family and Protective Services as the temporary managing conservator of Tanya. And that there will be no findings of abuse or neglect against Mr. Frere, as he is a non-offending parent. But we do find there is a necessity to rebuild the parent-child relationship between the child and him. We will go ahead and start visits between the child and each parent. The child may have visits with her older siblings. And if Aunt Sandra Diaz wants the home study, then I will sign an order for an expedited home study. I'm not ordering any child support or medical support at this time. I will see everybody back March 24th of 2026 on a 9 o'clock docket. We'll talk more about services and the things that we need to do in this case. Your attorneys will let you know the login information and what time that hearing will be scheduled. It will be on my 9 o'clock, my morning docket, but it may not be right at 9 o'clock. So they'll let you know when you need to get logged in. All right, I appreciate everybody. Thank you all very much for your cooperation and working with us and with Tanya. And I'll see everybody back here towards the end of March.
Thank you. Andrea, are you going to be the caseworker on this?
Yes.
Hey, if you speak with the aunt and she's willing to be placement, would you send me an email and we'll get that order done?
Yes, ma'am, I will.
Thank you, ma'am.
Your Honor, may I disconnect?
Yes, sir. Thank you very much. Everyone's
Okay.
free to go.
Thank you.
Thank you.